Okay, let's unpack this. Welcome to the deep dive. We are really fortunate today. We've got some incredibly valuable source material here. It's
Hmm.
been generously made available by the University of London for their students, and we really want to start by saying a huge thank you to them for, well, for providing such a rich and comprehensive resource.
Absolutely. And it's
Proud
important
to.
to say, these documents, they aren't just, a dry list of human rights. They really take you on a journey
Yeah.
into the history, the philosophy, the legal stuff, and maybe most importantly, the ongoing debates,
Mm.
the arguments that shape how we even think about what a human right actually is.
That's right. And speaking of journeys, this whole deep dive, it's designed with a really specific aim in mind. It's for educational use, specifically to help you, our listener, get a thorough handle on this material, to really, get you exam ready on what is, let's face it, a pretty complex topic.
Exactly. Think of us as your guides, navigating this, well, dense but fascinating landscape. We're going to systematically work through the source material, try and pull out the most crucial concepts, the challenging ideas, the key distinctions,
Yeah.
so you can really grasp the complexity of it all.
And before we properly dive in, just a quick thank you to our sponsor who makes these deep dives possible. This session is brought to you by Sinorbit Academy, Sri Lanka.
And yeah, a big good luck from us to all of you listeners who are getting ready for exams right now. We genuinely hope this deep dive is a really useful tool for your studies.
Okay, so today's focus, the nature of human rights. Now, the source document we're working from, it makes it crystal clear right from the start. This is not some simple, universally agreed upon set of entitlements.
No, definitely not.
It is, well, inherently a contested and complex field.
Precisely. And the core tension that kind of defines a lot of the discussion, the thing the document flags immediately, is this clash between universalism and cultural relativism. Are human rights something inherent to all humans, everywhere, just because we're human? Or are they actually shaped, maybe even limited, by specific cultures, histories, values?
In our exploration today, it's going to take us through some really key areas. We'll look at the foundational historical moments, the declarations that shaped our modern understanding. We'll touch on the philosophical ideas they supposedly rest on, or maybe don't rest on, depending on who you ask.
Hmm.
We'll get into the nitty-gritty of their legal implications, spend some time on a really crucial international conference that's Vienna 1993, and importantly, we'll examine alternative perspectives, specifically those articulated from Islamic and Asian traditions, as they are presented and analyzed within the source material.
And our aim isn't just to summarize. We really want to make sure you understand the nuances here. We want you to be able to talk about the main arguments, the counter-arguments, all as presented in the source. And we'll make a point of calling out important case names, key concepts, specific facts, maybe even repeat them a couple of times just to help them stick, especially if you're thinking about exams.
Okay, let's start right there then, with this fundamental idea that the nature of human rights is, well, contested. The source points us to some really foundational texts that set the stage for this whole debate.
And the absolute cornerstone of the modern international human rights system is, of course, the Universal Declaration of Human Rights, the UDHR, adopted back in 1948. And that preamble, it's incredibly powerful, really sets the
Who
tone.
does?
It talks about recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family, being the foundation of freedom, justice, and peace in the world.
Inherent dignity, equal, inalienable. These aren't just, nice sounding words. They're fundamental claims about where rights come from and who gets them. And Article 1 of the UDHR drives it home, doesn't it?
It really does. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood.
Oh.
And the absolutely critical phrase there, the one that really marked a major shift, is all human beings.
And to really get why that was such a shift, the source suggests looking back at earlier declarations that were definitely influential, like the United States Declaration of Independence from
Yeah.
1776.
Right, famously proclaiming, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, life, liberty, pursuit of happiness, and so on." But notice the scope, all men.
Exactly. And similarly, if you look at the French Declaration of the Rights of Man and of the Citizen from 1789, Article 1 says, men are born and remain free and equal in rights, and Article 4 talks about the limits of the natural rights of each man. Again, the focus is clearly, explicitly on men.
So this comparison, which our source material highlights, shows a really crucial evolution in thinking. The UDHR coming after World War II, after the horrors of the Holocaust, deliberately moved beyond that men language. By
Mm-hmm.
saying all human beings, the drafters were aiming for something much more inclusive, much more universal in scope. And that inclusive language, talking about all persons, that carried forward into the legally binding international treaties that came after the UDHR.
So, from these key texts, we see this core idea of universalism really taking shape. The basic assertion that rights belong to all humans, just because they're human. Your humanity is the ticket, basically.
But, and this is the big but, the source immediately raises. This is where the contestation really starts. Universalism presents this ideal, but as we'll see throughout this deep dive, and as the document lays out, there are powerful criticisms challenging this whole approach.
Yeah, critiques suggesting that this supposedly universal framework might actually be, maybe subtly, maybe not so subtly, imposing specific cultural, economic, or social norms that originated elsewhere, particularly, in the West.
And that leads you straight to the opposing view, the relativist position,
Yeah.
which argues that how we understand rights is, and maybe should be, culturally variable, shaped by the specific history, society, religion of different places.
And as we mentioned, the document flags that will be looking closely at alternative traditions, often labeled Asian, Chinese, Islamic human rights. Not just to note they exist, but to really analyze how compatible or maybe how fundamentally different they are from that UDHR framework.
And there's a critical point the source insists on right at the beginning, something we need to keep in our minds throughout. Unlike maybe some other textbooks, this source material explicitly states that international human rights are not simply an uncontested good, which are universally accepted.
Right, it stresses that.
Yeah, it demands that we engage head-on with the fact that this is simply not the case. Acknowledging this fundamental disagreement is absolutely key to critically understanding the field.
Definitely. So with that foundation laid, let's dig a bit deeper into the nature of these rights themselves. What do we actually mean by human rights, and what's their standing in, the legal world?
Okay, first, the meaning. The core idea, we've touched on it, is that these rights belong to everyone because they're human. Being human is the source. Simple as that, supposedly.
And that word from the UDHR preamble, inalienable, what does that really mean?
It means they can't be forfeited. You can't give them up. You can't renounce them. You're just endowed with them by existing as a human. Doesn't matter who you are or what you've done. The source uses the stark examples of, say, a convicted criminal or even a terrorist. Even they, according to this principle, retain their fundamental human rights. They can't be stripped away.
And the idea of equality is right there too, isn't it? Born free and equal. The ideal is everyone gets the same rights. But as the source quickly points out, the reality we see is huge inequality in how rights are actually enjoyed.
Which throws us back to those really fundamental, almost philosophical questions, like on what basis do we actually enjoy these rights? And maybe even more fundamentally, who or what counts as human anyway?
The source says, okay, the easiest definition is biological, human species. But that immediately feels limited. Why only biologically defined humans?
Exactly. And that naturally raises the really challenging question about sentient animals. The source mentions the argument, from some philosophers and activists, that animals like great apes, maybe dolphins, elephants, beings with complex intelligence, emotions, empathy, communication, social structures, maybe they possess attributes that should entitle them to some basic rights too.
It's a compelling argument in some ways.
It is, but the source is clear. There is absolutely no consensus among humans about extending rights to other species. We can barely agree on rights for humans. And even within human societies, rights are rarely, if ever, handed out just based on being biologically human.
Because societies tend to organize themselves along lines of difference, right?
Right.
Race, religion, gender, caste, class, nationality, all sorts of categories.
And historically, and depressingly often still today, societies actively create these categories of inferiors or outsiders who are just systematically denied the rights and privileges the dominant groups take for granted.
So figuring out inclusion and exclusion is crucial. And even if we just stick to humans, agreeing on what counts as basic human needs and what rights should flow from those needs, and crucially, on what basis those rights exist, is it religion, morality, economics, some inherent human nature? It's incredibly difficult to get agreement, philosophically or even just practically.
Philosophical accounts try to give us that basis. The idea of being endowed by a creator from the U.S. Declaration or having natural rights or believing in self-evident truths. These are philosophical claims.
But the source immediately asks, are they universally valid? Can you verify the creator claim? And if rights come from a creator, why did they initially seem to apply only to men? Are self-evident truths really self-evident to everyone across all cultures and times? Probably not.
Different philosophies stress different things, maybe language or
Yeah.
reason or the capacity for rational action. The source shares that really telling anecdote from the UDHR drafting,
Hmm.
the Chinese representative, Peng Chun-Chang.
Oh, yeah, what did he say?
He basically observed that the delegates could agree on which rights to put in the list, more or less. But they fundamentally disagreed on why those rights were rights. What was the basis? That tension was there right from the beginning.
Wow. That really shows the difficulty of finding a universally accepted philosophical grounding, doesn't it? So how does the source suggest we move forward?
Well, it suggests that for the practical purposes of international law, universality gets grounded pragmatically in the UDHR itself and the treaties that followed. It sort of shifts the focus away from this deep philosophical quest for the ultimate definition of human towards the ongoing practical importance of building a global culture of human rights.
Okay, so that's the meaning side. What about the legal nature of human rights? The source makes a distinction here.
Yeah, it points out that the word right in English has, well, at least two main senses. There's the moral sense, what's morally right or good, and then there's the political or legal sense.
And the legal sense is the stronger one for this discussion.
Generally, yes. It implies a specific relationship, a right holder and a duty bearer. And crucially, the right holder can, under the law, compel the duty bearer to do something or not do something, usually through the courts.
Okay, can you give examples?
Sure. The source uses private law examples like contract rights. If I break a contract with you, you have a legal right to take me to court to enforce it or get damages. Or think about beneficiary rights under a trustability. The beneficiary has rights against the trustee, enforceable in equity. These rights come from private agreements or established legal principles like equity.
And public law rights are different.
Different origin, yeah. They usually come from foundational documents like a constitution, laying out citizens' rights against the state, or from general principles of civil liberties developed through common law or statutes.
Now, what about the idea of human rights being paramount or fundamental? Does that hold up legally?
That, the source says, depends entirely on the specific domestic legal system you're looking at. It draws a contrast. Think about English law. The core principle there is parliamentary sovereignty. In theory, Parliament can pass any law it wants, even one that goes against what we might consider a fundamental human right. There aren't legally enforceable human rights in the sense that they absolutely cannot be overridden by Parliament.
Okay, so Parliament is supreme.
Right. But contrast that with countries that have written constitutions that entrench fundamental human rights. They make them very difficult to change or override with ordinary laws. In those systems, you can talk about human rights having a truly fundamental, legally enforceable nature that sits above regular legislation.
So the source is arguing that unless there's a specific positive law like a constitution or a treaty that's been fully incorporated into domestic law making human rights legally fundamental and enforceable in that strong sense,
Then they might be better understood as primarily political claims about how society ought to be, or as moral standards we use to judge whether a government is legitimate or not.
and we definitely see that political use of human rights all the time on the world stage.
Absolutely. The language of human rights has become a major tool to, as the source puts it, demonize other states. Think about the shift from the Cold War, where criticism might have been based on ideology, communism versus democracy, or maybe religion in earlier times. Now, accusations of human rights violations are central to international politics, the US or the EU criticizing China or Zimbabwe or Iran.
But the source points out this is often very selective.
Highly selective. States are much quicker to condemn abuses by countries they see as adversaries than by countries that are strategically important allies. The example given is the U.S. often criticizing certain nations while saying very little publicly about systematic problems in, say, some oil-rich allies around the Arabian Peninsula.
It's a clear double standard in practice.
It often appears that way. So this reinforces the source's distinction. You've got the philosophical ideal, you've got the fundamental legal nature where it actually exists domestically, and then you've got this very real political nature of human rights in international relations. Whether a right is truly binding depends heavily on recognition and enforceability within specific legal and political contexts. Some international norms are recognized and enforced. Others remain more like aspirations or tools for political leverage.
And the source poses activity 3.1 for us. Does this legal account fully capture the nature of human rights? It seems like the answer has to be no. right? The legal aspect is crucial, but you can't ignore the philosophical and political dimensions.
I think that's exactly right. It's a multifaceted concept.
Okay, let's just focus now. Move forward in time to a really pivotal moment discussed in the source, the Vienna Conference on Human Rights in 1993.
Yes, Vienna 93, a major global event. It marked the 45th anniversary of the UDHR, kind of a follow-up to an earlier conference in Tehran in 1968. You had representatives from 171 states there, plus loads of NGOs.
And what was the driving force behind it? Why hold this big conference then?
Well, for many of the strong proponents of the, global human rights project, there was a real sense of frustration. 45 years after the UDHR, they felt progress on getting effective international legal enforcement mechanisms up and running had been disappointingly slow.
Ah.
They wanted to push the agenda forward, really reaffirm and strengthen the commitment to universalism.
But it didn't quite go that smoothly, did it? The source highlights significant pushback.
Oh, absolutely. Vienna became a real flashpoint for a major wave of dissent against that dominant universalist view. And this dissent was articulated very strongly, very clearly. The source breaks it down into two main themes, although they sometimes bled into each other.
What were those two themes?
Theme one was really a challenge to the content and priorities of the existing international human rights framework. Critics argued there was too much focus on civil and political rights, things like free speech, voting, which they sometimes framed as luxuries or secondary issues, especially for developing countries.
While downplaying other rights.
Exactly. Downplaying economic, social, and cultural rights, like rights to food, health, education, work. The issue here wasn't necessarily a rejection of universality itself, but more about which rights were getting prioritized and where the implementation efforts were focused.
Was there a specific right they were pushing for?
Yes, a key demand within this theme was the explicit recognition of a right to development as a universal human right, putting it on the same level as civil and political rights. And that debate, as the source notes, feeds into later discussions about global poverty eradication.
Okay, so that's theme one, priorities and content. What was theme two?
Theme 2 went deeper. It challenged the very notion of universality itself. Proponents of this view argue that human rights aren't some abstract, inherent thing, but are fundamentally shaped by specific historical, social, political contexts.
So the idea that universal rights were actually...
Actually, modern Western values dressed up as universal truths, and implicitly, or sometimes explicitly, being imposed on non-Western societies. This perspective argued strongly that non-Western values, cultural traditions, the importance of community, these should be respected and given equal weight.
Was there a term for this?
Yeah, the concept of Asian values was explicitly brought up as an example of a different cultural framework with different priorities. And some pointed out, that even Western ideas like freedom and liberty aren't ancient traditions, but relatively recent developments linked to specific historical paths.
And the second theme, challenging universality, that's what got labeled cultural relativism.
That's the label that stuck, yes. But it's important, as the source points out, that the term was sometimes used quite loosely, often encompassing the first theme about priorities as well, so it could be a bit confusing.
Were specific countries leading this dissent?
Yes. The source mentions that often the same group of nations supported both lines of argument. Countries like China, Singapore, Malaysia, Cuba, and the seats of the former USSR were particularly vocal in raising these challenges at Vienna.
And what was the common thread uniting these dissenting views?
A shared skepticism, maybe even cynicism about the whole international human rights project. A feeling that it was just another way for Western powers to exert influence and advance their own interests, rather than genuinely promoting rights for everyone.
So the source summarizes the kinds of challenging questions that this dissent really forced onto the agenda at Vienna, questions still debated today.
Right, like, are human rights demands and enforcement really universal? Or are they selective, based on Western strategic interests? Which rights get prioritized, and are they actually the most helpful ones for developing countries? Why the reluctance from some powerful states to fully embrace a binding right to development?
And is the whole concept maybe ethnocentric, taking a specific Western experience and trying to apply it everywhere, potentially damaging other valuable cultural traditions? Are non-Western traditions, Islamic, Chinese, just being ignored or dismissed?
These were the core questions being pushed. Now, despite how loud and forceful this dissent was, the source says it was ultimately unsuccessful in completely derailing the universalist agenda at the conference.
But it did have an impact.
It definitely did. The source says it had an important impact on some of the key formulations in the final document, and just the sheer volume of the dissent was notable. It couldn't be ignored.
So what was the final outcome document?
It was the Vienna Declaration and Program of Action, the VDPA, adopted in June 1993, later endorsed by the UN General Assembly, and the main thrust was a reaffirmation of the universality of human rights.
How did they phrase it?
The VDPA characterized human rights as universal, indivisible, and interdependent and interrelated. The goal stated was to give them a more effective legal reality.
And the source highlights a particularly significant statement in the VDPA.
Yes, the statement that the promotion and protection of all human rights is a legitimate concern of the international community. The source argues this marks a significant erosion of the sovereign power of states. The traditional idea, found in Article 2(7) of the UN Charter, that how a state treats its own citizens is purely an internal affair.
But it cautions against saying that internal affairs argument is dead.
Right. It says arguing it's now totally redundant is simply incorrect. States still fiercely guard their sovereignty when it comes to international scrutiny of their rights records.
And the actual wording of the VDPA reflects the compromise, the tension.
Absolutely. You can see the push and pull. Part 1, paragraph 1 boldly states the universal nature of these rights and freedoms is beyond question. But then just a few paragraphs later, Part 1, paragraph 5 adds that crucial qualification.
The one influenced by the dissent.
Exactly, it says. While the significance of national and regional particularities and various historical, cultural, and religious backgrounds must be borne in mind, it is the duty of the states, regardless of their political, economic, and cultural systems, to promote and protect all human rights and fundamental freedoms.
So universal duty, but acknowledge diversity. That's the balancing act.
That's the formula they landed on.
Hmm.
And the source points to that specific sentence in paragraph 5 as the place where the dissent arguably had its most direct impact on the VDPA's text.
The source also mentions another way diversity gets accommodated, through the treaty process itself.
Yeah, it makes the point that while the original UDHR drafters were mostly Western, the big international treaties that followed were negotiated over decades with a much more diverse group of states. Their influence is reflected in the texts. Plus, states aren't forced to sign up. They can choose not to ratify, or they can ratify but enter reservations, basically opting out of specific articles they disagree with.
So that consensus-based approach allows for some diversity.
It can, yes. It provides a mechanism to potentially counter the simple "it's just Western values" critique. However, the source also cautions that on some issues, like disagreements around religious freedom, the contention seems to have become more entrenched over time, not less.
Okay. And the source gets us thinking with activity 3.2. Where exactly did the dissent impact the VDPA? What kind of impact? Is religion just a particularity to bear in mind, or something more fundamental? And what are the implications of saying rights are universal, indivisible, and interdependent and interrelated? That last bit seems key, linking all types of rights together, pushing back against prioritizing civil political over economic, social, cultural.
Precisely. It was a direct response to that Theme 1 dissent we discussed.
This leads us nicely into looking more closely at that framework that really came out of Vienna, the universalism versus cultural relativism debate. The source says this became the standard way to talk about disagreements after '93.
Yeah, especially in dialogues between, say, the West and the Islamic world or the global North and South. It's the common shorthand.
But the source is critical of these labels.
Very critical. It argues they lack nuance and verge on the inaccurate. For starters, Muslim-majority states aren't a monolith. Think about the huge differences between Turkey, Indonesia, Saudi Arabia, Senegal.
Right.
Are their objections always the same? Are they purely cultural or faith-based? Or maybe economic or political? And is there really one single Islamic approach? The source strongly suggests these simple labels just don't capture the complexity.
The source also clarifies universalism in the context of treaties, right?
Yes, it points out that when the UDHR is called universal, or treaties talk about universal application, the primary meaning is often simply that these treaties are open for all states to join. This distinguishes them from regional treaties like the European Convention on Human Rights or the African Charter, which are geographically limited. You have to be eligible to join those.
And even within those regional systems,
There's still significant diversity. The source used the example of the right to life. European states differ on abortion or euthanasia. African states differ on the death penalty. Even among supposedly like-minded states in a region, you find real differences in interpretation and practice.
So the source suggests relativism in practice is often more, well, relative.
Hmm.
It's not usually an all or nothing rejection.
Exactly. It's often more about navigating differences and finding a core of agreement rather than a complete denial of any shared values.
Okay, let's go back to the theoretical universalist view again, the one that's not just about treaty scope. What's the core assumption there?
It often assumes that rights exist objectively, somehow independent of any specific culture, religion, or ideology. They're based on some fundamental shared human characteristic, reason, dignity, whatever, and therefore apply to everyone, everywhere.
And law, in this view, doesn't create rights, it just recognizes them.
Right. Treaties, constitutions, they articulate rights that already exist, maybe as natural rights. So international human rights law, from this perspective, has this double validity. It's positive law made by states, yes, but it also rests on this deeper, independent foundation in our shared humanity. It's often linked to modern natural law thinking. And the source poses some critical self-assessment questions about this view. Does it assume human nature exists outside of culture? Does it lean towards seeing humans as isolated individuals? Does it tend to privilege civil and political rights? Important things to think about critically.
The source then brings in a specific voice advocating for universalism. Dame Rosalind Higgins, former president of the ICJ.
Yes, a very prominent universalist. Her key assertion was that objections to universalism, the relativist arguments, mostly came by states and by liberal scholars anxious not to impose the Western view. But crucially, she argued, these objections are rarely advanced by the oppressed, who are only too anxious to benefit from perceived universal standards.
That's a strong claim.
It is. She pointed to the VDPA language about bearing particularities in mind, but stressed the overriding duty of states to protect rights, regardless of their political, economic, and cultural systems.
And what was her own basis for this universalism?
She spoke of her profound belief in the universality of the human spirit, and she listed things she believed individuals everywhere want: food, shelter, free speech, freedom of religion or no religion, security from the state, no torture, fair trial. Basic stuff.
And she claimed these are universal desires.
Yes, independent of culture, religion, development level. Felt equally by, as she put it, an African tribesman as by the European city dweller, by the inhabitant of a Latin American shanty town, as by the resident of a Manhattan apartment.
How does the source react to Dame Higgins' view?
It offers a critique. It calls her view understandable, given her background, but arguably also rather misplaced. It directly questions her basis for knowing the views of someone in a shanty town. How can she assert with such confidence that individuals everywhere want the same things? What's the evidence?
So it suggests it might be an assumption.
An understandable assumption, perhaps, but one that needs interrogation. The source pushes us with Activity 3.3 to analyze her "I believe" statement, compare human spirit to her list of wants, think about what she implies cultural relativism is, and evaluate if her assertion is inherently more valid than a relativist one. It forces critical engagement.
This critique leads into another key issue: individualism. Is focusing on the individual essential for human rights?
Well, the relativist critique often argues that individualism itself is culturally specific, linked strongly to Western modernity, the Enlightenment, the process of breaking free from older collective identities, clan, family, rank, gender roles.
Connected to the rights of man discourse and the Industrial Revolution.
Exactly. The argument is that the relative prosperity in the industrializing West allowed for this emphasis on individual liberties like free speech and belief. So it reflects a particular European historical path, not a universal human condition.
And therefore, trying to universalize a human rights framework based heavily on individualism is essentially imposing this Western norm and history on others.
That's the critique. But the source adds nuance here. It says, not all universalists equate human with some pre-social, isolated individual. There are more sophisticated universalist views.
Like what?
Views that argue our core human needs and capabilities actually develop within society. So rights might arise from our social nature, not in opposition to it.
Who represents this kind of view?
A key example given is the philosopher Martha Nussbaum. She builds on liberal thinkers like Kant and Rawls, but puts huge emphasis on human dignity, echoing the UDHR.
What's her core idea?
That all humans, just by being human, are of equal dignity and worth. And this worth comes from our power of moral choice, our ability to plan our own life.
And this connects to the capabilities approach with Amartya Sen.
Yes, exactly. Developed with Nobel laureate Amartya Sen. Instead of just listing rights, the capabilities approach asks, what are people actually able to do and be? What substantial freedoms do they have? like living a long, healthy life, getting educated, participating politically. Sen's books like Development is Freedom and The Idea of Justice are really influential here.
And Nussbaum developed a list of these core capabilities.
She did. A detailed list covering things like life, quality and length, bodily health, integrity, senses, imagination, thought, emotions, practical reason. It covers much of the ground of the UDHR and treaties, but frames it around human capabilities and dignity.
And this approach is influential.
Hugely influential, the source says, especially among liberal scholars and activists. And here's a critical point. This capabilities approach represents a significant critique of the existing International Human Rights Project, but from a universalist perspective.
Ah, so not all critique is relativist.
Absolutely not. The source really hammers this home. The simple universalism versus cultural relativism split is misleading because it implies all deep critiques come from relativists. It simply is not the case, the source says. There are major critiques coming from within the universalist camp, too.
Okay, so if that dichotomy is too simple, what is cultural relativism in its purest form, logically speaking?
Logically, it's the claim that there are no universal human values, practices, or even needs. None whatsoever.
And if you take that to its extreme?
It means any practice can only be understood and judged within its own cultural context. There's no external, objective standpoint for criticism or intervention, no universal measuring stick.
The source uses some very sensitive examples here.
Yes, it discusses female genital mutilation, FGM, practiced in some societies, justified by appeals to culture, tradition, sometimes religion. The source notes how the English term itself shifted from circumcision or cutting to mutilation, showing a value judgment based on perceived harm. Many countries, like Ethiopia and the UK, with laws like the Prohibition of Female Circumcision Act 1985 and the Female Genital Mutilation Act 2003, amended by the Serious Crime Act 2015, have criminalized it due to severe health risks.
An extreme relativist would say.
That it's purely a matter for, say, Ethiopia to decide based on its norms. Outsiders have no basis to criticize or intervene, regardless of the harm involved.
And the other example.
Corporal and capital punishment in places like Saudi Arabia, stoning, amputation, whipping, sometimes defended as implementing God's law under specific interpretations like Wahhabism. An extreme relativist might argue that if this is justified by the society's dominant understanding of divine law, it's beyond external reproach.
But the source says this extreme view is rare.
Yes, it explicitly states this radical form is not particularly common. Most arguments framed as relativism are more nuanced.
Often framed as individualism versus collectivism.
Right. Does dignity only attach to individuals? Or can collective rights exist? Are non-Western societies inherently more collective? It's a common way the debate is framed.
Sometimes linked to Cold War politics, too.
Yeah, sometimes equated simplistically with democracy versus socialism, communism, portraying socialist systems as swallowing the individual into the collective.
The source also critiques how cultural relativism is sometimes presented.
Yes. It points out the danger of presenting cultures as these static, separate boxes that don't interact or change, which ignores the reality of globalization and cultural exchange. And similarly, religions are often portrayed as monolithic and unchanging, which the source rightly says they absolutely are not. This leads the source to suggest that when we look at Islamic and Asian accounts, we'll often find strong universalist elements within them, just articulated differently. So maybe the tension isn't you versus R, but different versions of universalism clashing. Islamic accounts, for instance, might represent a potential rival universalism, creating tension perhaps between secular and divine bases for rights.
And it warns against a simple West Islam opposition.
Definitely. Calls it reductive, ignoring internal diversity and historical exchange. But it acknowledges real points of conflict with the UDHR framework do exist.
The source mentions briefly that proponents often argue the current framework fits within other religions too. Hinduism, Judaism, Confucianism.
Yes, referencing Green and Witt. The argument is often made that human rights reflect common values, not just Western Christian ones.
But there's a critique of that too.
Yeah, the critique is that this can be retrospective, finding justifications after the fact, rather than challenging how the current framework was actually formed, which arguably does reflect specific Western historical experiences. Islam often gets singled out, the source suggests, because it's perceived as offering a more direct, competing version of universalism.
Which brings us to activity 3.4. If universal standards clash with local norms, should the universal standard win? That's the million-dollar question, isn't it?
That is the absolute crux of the matter.
Okay, let's tackle the specific articulations of rights in Islam. The source stresses right away this is incredibly complex and contested.
Hugely complex, massive literature, countless views, historical, theological, legal. The source even notes the argument, citing scholars like Ahmed, that talking about one Islam is inaccurate. Maybe we should talk about Islams in the plural, which makes defining one definitive Islamic position on something like the right to life almost impossible.
But the source says we have to engage with it. Why?
Because the Islamic defense is constantly used by governments of Muslim-majority states to justify their positions on international human rights issues. And crucially, different states take completely opposite views on certain issues, yet both claim their stance is justified by Islam.
So the internal disagreement is key.
It's key evidence of the plurality. And further evidence, the source points out, is the fact that there is no single legally binding treaty in force that sets out an agreed-upon human rights framework specifically rooted in Islam.
Unlike the UN system.
Exactly. Every single Muslim-majority state, theocracies, secular states, mixed systems, is party to some UN human rights treaties. Treaties designed to be universal, not tied to one religion or a culture.
So since there's no single binding Islamic treaty, how does the source approach this?
It examines several influential documents that try to articulate an Islamic approach, but it critically notes right up front that each one lacks credibility in different ways. Important to remember that. The documents are the Universal Islamic Declaration of Human Rights, UIDHR, the Cairo Declaration on Human Rights in Islam, CDHR, and the Arab Charter on Human Rights.
Let's start with the Universal Islamic Declaration of Human Rights, UIDHR. What's the issue with its credibility?
Primarily that it wasn't created by governments. It was drafted by a private organization, the Islamic Council of Europe, compiled by sort of self-appointed figures. And according to commentators like Eva Brems, it hasn't actually received that much attention.
But it's still useful for study.
Yes, because it's an attempt to frame rights using Islamic concepts. Its foreword explicitly bases it on the Quran and the Sunnah, the Prophet Muhammad's practice. It states, God is the lawgiver, the ultimate source of rights.
And because they're from God.
They're considered inviolable by human rulers. They're integral to the Islamic order, and implementing them is obligatory for Muslim governments, but only within that specific Islamic framework. The foreword also acknowledges these rights are often violated, even in Muslim countries.
How does its source compare to the UDHR's claimed sources?
Well, the UIDHR is expressly sacred God's law. The UDHR has roots in natural law, which historically was often linked to God's law, so there's some overlap in the idea of a higher source. The UIDHR claims this ideal code existed 14 centuries ago, binding individuals and governments, aiming for dignity, ending exploitation, similar aims to the UDHR.
Where's the key difference then?
The difference comes because Islam has its own distinct norms, creating a distinct identity, which potentially leads to distinctions in rights or status between Muslims and non-Muslims.
So are the UIDHR rights universal?
Arguably not in application if they only fully apply to Muslims. But the source notes, since Islam is evangelical, you can convert. They're potentially universal in that sense. Anyone can join the group that holds the rights.
Okay, moving on to the Cairo Declaration on Human Rights in Islam. CDHRI. The source says this one is more credible.
More credible, yes, mainly because it was adopted under the Organization of the Islamic Conference, OIC, now the Organization of Islamic Cooperation. That's an international body of 56 Muslim-majority states, and its charter is explicitly Islamic. It was adopted in 1990.
But does it have teeth, like the UN system?
No, that's the key point. There's no international body supervising or protecting these Islamic rights. The CDHRI is a declaration, which means it's not legally binding like a treaty. And crucially, it has no enforcement or supervisory mechanisms attached.
Which leads to that paradox the source mentions.
Exactly. The very same states that adopted this non-binding declaration are parties to UN treaties that are legally binding and do have international scrutiny mechanisms. They accept UN scrutiny, but seemingly not scrutiny under a non-binding Islamic framework.
Why might that be?
The source suggests several reasons. Potential conflicts with their other international legal obligations, the sheer difficulty of agreeing on Islamic principles that fit with diverse domestic laws, many aren't purely Sharia-based, and just the fundamental plurality within Islam itself, making a single authoritative text very hard to achieve.
What's actually in the CDHRI? It has 25 articles.
Yes. Article 1 frames humanity as one family united by submission to God, equal in dignity, humans as God's vice-garant. Rights are seen as helping Muslims serve God.
And the rights listed.
A broad range, many overlapping with the UDHR. Right to life, rules for conflict, burial rights, marriage, rights for women, children, legal capacity, education, religious instruction, no forced conversion, right to work, property, environment, privacy, equality before law, due process, no hostage-taking, free expression, public participation.
It also has that article reflecting colonial history.
Yes, Article 11. Asserts humans are born free, prohibits slavery and oppression, only subjugation to none but God. It explicitly prohibits colonialism, affirms self-determination for colonized peoples, a duty to support their struggle, and the right to preserve identity and control resources. Shows how shared history shapes rights language.
But then come the crucial limitations, Articles 24 and 25.
This is the absolute key. Article 24. All the rights and freedoms stipulated in this declaration are subject to the Islamic Sharia. And Article 25 leaves no doubt. The Islamic Sharia is the only source of reference for the explanation or clarification to any of the articles of this declaration. Everything is subordinate to Sharia.
How does the source assess the CDHRI overall?
It sees it as a clear response to the UDHR, drafted with little Muslim input. Adopted after the UN treaty system was fully operational. It highlights the paradox again, accepting UN scrutiny but not scrutiny under a non-binding Islamic declaration.
And while there's overlap on rights,
The perspective is different, and Articles 24-25 make the subordination to Sharia explicit. What that means in practice is fuzzy, because states interpret and apply Sharia so differently. But the source identifies recurring themes where interpretations of Sharia often clash with international standards.
particularly discrimination against women and non-Muslims.
Yes, and the source gives specific examples of discrimination against women based on different schools of Islamic law, fiqh, and state practices. These are important to remember, so let's recap them.
Okay.
First, choice of husband often requires a male guardian's consent, potentially leading to forced marriage even if the woman nominally consents. Second, polygamy. Quran permits up to 4 wives, accepted in most Muslim countries, though some restrict or ban it. Third, divorce. Generally much easier for men. Women's rights may depend on limited grounds or marriage contract stipulations. Fourth, child custody. Mother gets young kids, father is guardian. Custody often transfers to father later, and mother can lose custody if he remarries. Fifth, inheritance. Often a man's share is double a woman's in the same relationship, e.g. son versus daughter.
And testimony and freedom of movement.
Right. Sixth, testimony. 2 women's testimonies sometimes equals 1 man's. And finally, freedom of movement hijab.
Yeah.
Contentious. While both genders must dress modestly, all feast schools generally require women to cover hair body in public. Some states legally mandate specific dress. Some interpretations restrict women driving alone or traveling without a male chaperone. The source stresses these practices, derived from certain interpretations, are discriminatory in many, though not all, Muslim states, and are major points of friction with international standards.
Okay, that's the CDHRI. Now, the Arab Charter on Human Rights 2004, this is different.
Significantly different, yes. First, it's a treaty intended to be legally binding, unlike the CDHRI declaration. It even has a supervisory mechanism. It came into force in 2008.
And it's under the Arab League.
Yes, adopted under the Arab League, which brings together states defined more by Arab culture orientation. Most are Muslim majority, but they have religious minorities too.
What's the key feature here?
What's really striking, according to the source, is the surprisingly limited role given explicitly to religion, especially Islam, compared to the Cairo Declaration. And very importantly, the Arab Charter makes express reference to the universality of all human rights.
The preamble shows this.
Yes, it's quite revealing. It mentions dignity being exalted by God, the region being a cradle of religions. It talks about freedom, justice, equality, and principles like fraternity and tolerance, consecrated by the noble Islamic religion and the other divinely revealed religions. It references Arab values, Arab unity, self-determination, sovereignty of law. It's a mix of religious reference, cultural pride, and universalist language.
And the rights themselves.
A broad, comprehensive list, very much in line with universal treaties: self-determination, non-discrimination, life, no torture, fair trial, privacy, religion, expression, work, development, etc. Even the limitation clauses are drafted similarly to those in universal treaties.
But what's the killer contrast with the CDHRI?
It's Article 43. This says, nothing in the Arab Charter should be interpreted as impairing rights protected by a state's own domestic law or by other international or regional instruments the state is party to, explicitly including rights of women, children, minorities.
Ah, so it explicitly respects other international law, unlike the CDHRI putting Sharia above everything.
Exactly. It's a fundamental difference in approach. Article 43 shows a firm commitment to upholding other international treaty obligations, not subordinating them.
So the source sees the Arab Charter as a very different approach to relativity,
Discernibly different, yes. Not without its own problems from a universalist view, but clearly distinct from the UIDHR-CDHRI model.
which highlights that paradox again.
Right. Islamic relatives and arguments persist. Practices differ hugely, yet these states are fully engaged in the international system, shaping norms, sometimes blocking them. It's incredibly complex and nuanced.
And it leads to Activity 3.5.
Yeah.
Given all this diversity, is it even accurate to talk about Islamic human rights as one single thing?
A very good question the source leaves us with.
Okay, let's shift focus again to another major alternative perspective, the Bangkok Declaration and the notion of Asian human rights.
Right, the Bangkok Declaration. This was a really significant statement from a group of Asian nations issued right at the Vienna Conference in 1993. It was seen as a bold assertion of autonomy, intellectual, political, legal, and frankly, a surprising level of collective resistance to the dominant universalist narrative, tied to an affirmation of so-called Asian values.
And it's still relevant today?
The source argues yes. Even though it's from 93, and there have been regional developments since, like the ASEAN Human Rights Body, the Bangkok Declaration remains one of the clearest statements of a general position held by many of these states.
What did it actually say?
Well, it starts by acknowledging international human rights are important, but then it immediately pivots, stressing the need for a just and balanced approach, and explicitly referencing Asian traditions and inheritances that do not share Western values.
It also talks about universality, but critically.
Yes, it emphasizes universality, objectivity, and non-selectivity, and the need to avoid double standards
Yeah.
and politicization.
Which implies.
It implies a critique,
Right.
that powerful Western nations aren't objective or non-selective, that they apply human rights with double standards and use them for political purposes, biased towards their own values and interests.
What were the more specific objections?
Several clear ones: the importance of social and economic rights, the specific call for the right to development, and critically, the demand to delink foreign aid from human rights conditions. They argued development aid shouldn't be conditional on meeting Western human rights benchmarks.
So a core part of the Asian objection was this critique of Western selectivity and hypocrisy.
Absolutely. Accusing Western nations of highlighting abuses in countries they opposed, while conveniently ignoring similar problems in allied states.
And there was a strong emphasis on sovereignty.
Very strong. Repeatedly asserting the right of states to choose their own political systems, control their resources, pursue their own development paths, without external interference dressed up as human rights promotion.
Linked to historical experiences.
Yes, particularly colonialism. The Declaration affirms self-determination for colonized peoples, but then adds that important caveat. This right should not be used to undermine the territorial integrity, national sovereignty, or political independence of states. Similar concerns about sovereignty we saw in the Arab Charter and African system discussions.
And it made this point very current.
Extremely current for the time, yes. It made an explicit reference to the Palestinian situation, supporting their right to self-determination and demanding an end to violations in occupied territories, Palestine, the Syrian Golan, Jerusalem.
So the source argues this Asian human rights discourse is more than just a philosophical debate.
Much more. It's a multi-layered political claim. It's criticizing specific Western policies, asserting state sovereignty, and arguing that different cultural traditions genuinely hold different, valid understandings and priorities regarding rights.
How did the Bangkok Declaration frame universality itself?
In that nuanced way we saw emerging, it said, while human rights are universal in nature, they must be considered in the context of a dynamic and evolving process, bearing in mind the significance of national and regional particularities and various historical, cultural, and religious backgrounds. Very similar language to what ended up in the VDPA.
Who are the key figures pushing this Asian values idea?
The source names Lee Kuan Yew, the influential former Prime Minister of Singapore, associated with the Singapore School of Thought, and Mahathir Mohamad, former PM of Malaysia. Their views were very prominent. The source uses the Singapore School as a key example.
What was the core argument from Lee Kuan Yew and the Singapore School?
A fundamental difference, they argued, between Western concepts, supposedly focused on the individual, and East Asian concepts, prioritizing society over the individual. And they linked this directly to what was needed for economic and social development in Asia.
Using Singapore as the model.
Exactly. Singapore, tiny island, huge economic success, but achieved alongside severe restrictions on political rights and civil liberties. The justification. These restrictions were necessary for social stability, order, discipline, things deemed essential for rapid growth and the good of the whole society. The trade-off was prosperity, education, healthcare, in return for less individual political freedom. Collective welfare first.
The source quotes another Singaporean leader, too.
Yes, Goh Chok Tong. He said success needs more than just economics. It needs non-economic factors, a sense of community and nationhood, a disciplined and hardworking people, strong moral values, and family ties. Basically arguing that the type of society, its collective values and solidarity, determines performance more than just individualism.
Okay, besides Singapore, the source looks at China's perspective.
Yes, specifically examining a document from the Beijing Review in 1991 called Human Rights in China, which came out after the Tiananmen Square events of 1989.
And China affirmed universality.
Significantly, yes. It called human rights a matter of great significance and common concern, supported UN declarations, and even praised the UDHR as a foundation. That was quite notable.
But with caveats.
Big caveats. Like the Bangkok Declaration, it wasn't a full embrace of the Western model. It immediately stressed the absolute importance of context. The source quotes it, "The evolution is circumscribed by the historical, social, economic, and cultural conditions. The issue of human rights falls by and large within the sovereignty of each country."
So no judging from outside based on preconceived models.
Exactly. History and conditions matter most. Universal claims take a backseat to national, social, economic, and cultural specificity and sovereignty.
Did China offer its own view of what makes its approach to rights unique?
It did. Claiming power belongs to the people via the Constitution, it highlighted three salient characteristics of human rights in China. Worth repeating these. First, extensiveness. Rights supposedly cover the whole population, including survival, personal, political, and economic, cultural, social rights, safeguarding both individual and collective rights.
Second.
Equality. Claiming the socialist system ended exploitation, so rights are enjoyed equally, regardless of wealth, race, sex, background, religion, etc.
And third.
Authenticity.
Yeah.
Claiming the state provides real guarantees through its system, laws, material means, so rights match reality, and policies are endorsed by the people.
How does the source engage with these claims critically?
Yes, critically, but acknowledging complexity.
Yeah.
It recognizes China's incredible success in economic growth and poverty reduction, a remarkable achievement. It notes the parallel with Singapore, restrictive political order, emphasis on collective, leading to economic growth. But it rightly says, we can't know what would have happened under different models, and we absolutely must be critical of government statements about their own human rights records, especially in restrictive systems.
And then the source brings in the massive counterpoint, the treatment of the Uyghurs.
Yes, a crucial counterpoint and limit to the Asian values argument. The source calls the alleged treatment of the Uyghur minority, who are mostly Muslim, exceptionally discriminatory.
What are the allegations?
Since 2018, reports of mass detentions in camps, torture, forced brainwashing, actions some call cultural genocide. Though the source notes that specific term isn't substantiated in the material itself, the description of the actions is there.
And China's response?
Denial or justification as necessary re-education, training, or counterterrorism. The source also notes the striking lack of public criticism from other states in forums like the UN General Assembly.
What's the source's conclusion on the Uyghur situation and Asian values?
It asks whether it's repression, security, eradication, or a mix. But it states unequivocally, these credible allegations cannot be justified by appeals to Asian values, prioritizing the collective or stability. The situation shows a clear limit to that argument's legitimacy. It even provides a BBC link for more info. And the source asks us to think, what kind of approach does China really represent? Is it just relativism or something else entirely?
Then Activity 3.6 pushes us on the Asian values label. Is calling it relativist only partially helpful? Is it maybe more fundamentally about political responses, asserting sovereignty, critiquing hypocrisy, demanding different development paths than just pure cultural difference?
It really forces you to see the multiple layers involved.
Okay. Drawing things towards a conclusion now, the source revisits the universalism versus relativism debate.
And suggests it's maybe not the most helpful framing, potentially even a distraction from other critical issues.
Like, what's the alternative perspective offered?
It points towards a view emerging even back at Vienna 93. Maybe the core problem isn't just differing values, but the systematic exclusion of certain groups or experiences from how rights are defined and realized in the first place. The modern approach tries to be more sensitive to the problems of applying abstract universals without considering diverse realities.
So the contemporary defense of human rights tries to blend things.
Yes, a commitment to universalism combined with a necessary sensitivity to diversity and cultural specificity. It points back to that VDPA language, acknowledge national and regional particularities, but maintain the universal duty of states, regardless of systems, to protect all rights.
But the source gives us a sharp reality check on how universal things actually are.
Oh yes. Despite all the declarations, the reality is far from universal implementation. There's no universal ratification of all treaties. There are very significant gaps in putting them in practice, even where ratified. And states use a myriad of reservations, some so broad they arguably negate the effect of the treaty on certain points for that state. Ratification definitely does not equal respect on the ground.
So if the UVSR debate is a distraction, what's a key issue contemporary efforts need to focus on?
Addressing continued exclusion. Not just historical exclusions like women or children, but ongoing marginalization of groups like indigenous peoples and minorities. The source identifies violations of minority rights as a major source of human rights violations. Globally, discrimination based on religion, culture, ethnicity, race, and increasingly sexual orientation.
And the trend over the last 50 years hasn't necessarily been creating brand new rights.
Not primarily, according to the source, though it acknowledges Alston's point about claims for new rights. The main focus has been on ensuring that excluded groups have their existing rights better recognized, elaborated upon, and more effectively protected, making the existing framework work for everyone.
Examples being?
Efforts focused on the rights of women, children, persons with disabilities, migrant workers, indigenous peoples. The law evolves because the challenges aren't the same for everyone.
Like indigenous peoples.
Exactly. Their distinct identities, their unique relationship with land, well, these were historically ignored. Land rights affect them differently and more profoundly.
And discrimination based on sexual orientation.
The source mentions the ongoing development of norms here, calling it a battle with states taking very diverse views, referencing Alston and Goodman. It shows the system can adapt to address new forms of exclusion, but it's often a fight.
So how do we wrap our heads around all this complexity, this contestation? The source introduces a philosophical perspective from Kostas Douzinas.
Yes, from his work The End of Human Rights, Douzinas offers a lens to understand why rights are so fought over.
What are his key points?
He argues rights are deeply antagonistic. The constant struggles to extend them prove this. He links rights recognition directly to our sense of existence, how others see us, our self-esteem, the very basis of our identity. We strive, he says, for recognition of our unique identity.
But there's a problem with law and identity.
A mismatch. Our self-image is complex, fluid. Law tries to capture identity, but its categories are often rigid, inadequate. Law is a necessary but inadequate and defective partner in this identity struggle. True identity, Douzinas argues, isn't ultimately found in universal law, but in the continuous struggle for the other's unique desire and concrete recognition.
So rights are like a battlefield.
A battlefield with ethical dimensions, yes. Social conflict isn't just bad. It can be how political and ethical community develops. Desire, he says, always runs ahead of law, seeking recognition. But achieving legal recognition can sometimes stifle the very desire that drove the struggle. Human rights, for Douzinas, actively create selves through this intertwining with identity and desire.
How does that help us understand the material?
It suggests the conflict isn't a bug, it's a feature. Rights operate where identity is contested. People use law to assert identity, individual or group, but law is never the whole story. The struggle for recognition of that other's unique desire continues outside the legal framework. The key term is political desire.
How would this apply to, say, Islamic rights claims?
You could see articulating a framework of Islamic rights, like the CDHRI, as less about technical legal points and more as a claim for Islamic identity or a particular version of it, to be recognized as a valid alternative tradition globally. It uses legal forms, but it's driven by deeper social religious identity concerns.
And the issue of Sharia.
Not just about reconciling legal codes. Claims for Sharia recognition become fundamental assertions of a legal tradition deeply bound up with claims to Islamic identity itself. It's about recognition at a much deeper level.
Okay, one final really important point the source raises.
Yes, challenging the assumption that human rights are universally accepted even in the West.
Oh.
They've always faced challenges. And the source points to the contemporary global rise of populism.
With examples like Italy, France, Brazil, Hungary, Poland, and significantly,
The election of Donald Trump in the U.S., seen as perhaps the most significant example impacting a core state traditionally associated with championing human rights.
and this populism challenges the human rights movement.
Deeply, it challenges long-held assumptions, norms, taken for granted ideas that have underpinned the movement since World War II. The source cites Philip Alston's article, The Populist Challenge to Human Rights, as something important for listeners to look into, connecting our discussion to current global politics.
So the contestation continues even within the West.
Absolutely.
Yeah.
It shows the nature of human rights remains fundamentally contested everywhere.
So, bringing this all together, the aim is that you, our listener, can now approach international human rights not as a simple list, but as this complex, contested, evolving field. You should be able to spot universalist ideas and the critiques against them.
And describe those alternative traditions from Islamic and Asian contexts, discuss how rights function as expressions of political and cultural identity, and really critically analyze that whole universalism versus cultural relativism framing, seeing its limitations.
The source even gives a sample exam question to test this understanding. The nature of human rights is contested. This is itself positive. Consensus would prevent the development of human rights. Discuss.
And the advice is crucial. Don't just list things. Break it down. Is it contested? Yes, clearly. Is contestation positive? Maybe, sometimes. Does consensus prevent development? Perhaps. Or maybe it solidifies gains.
So you'd argue it's contested using examples like different traditions, critiques, political uses.
Right. Then argue contests can be positive, pushing for social economic rights, including excluded groups, but also argue contestation can lead to conflict or stalemate, like clashes over Sharia interpretations versus universal standards. And sometimes the lack of consensus on issues just means different traditions diverge.
It really forces you to weigh the arguments. Understanding human rights means grappling with all these layers: history, philosophy, law, politics, identity. No easy answers.
It's about appreciating the depth of the questions involved.
Well, we've certainly covered a lot of ground in this deep dive today, exploring the historical roots, the philosophical debates, the legal tangles, the cultural contests, all surrounding the nature of human rights, and all guided by that excellent source material from the University of London.
And the core takeaway, as the source drives home again and again, is that human rights are fundamentally contested. They aren't static. They aren't universally accepted without question. It's a dynamic field, constantly being shaped by history, culture, politics, and struggles over identity.
Understanding that contestation is so important. It helps you move past a simplistic view and really appreciate the nuances, the challenges, the ongoing struggles involved in trying to make rights real for everyone.
And maybe as a final thought, looping back to Costas Douzinas, that link between rights, desire, and the struggle for identity. How does that ongoing, maybe endless, struggle keep shaping human rights discourse today? Especially with challenges like populism that the source flagged right at the end. It's a field that demands our ongoing critical attention.
Indeed it does. Thank you so much for joining us for this deep dive into the nature of human rights.
Yes, thank you. We really hope this discussion has been valuable for your studies and your exam preparation.
And once again, from both of us, very best of luck with those exams.
Until next time on The Deep Dive.